Welcome to my first live stream on my new channel, listingattorney.com. I am hoping I can figure out how to share my screen because I'd like to make the case for you today that listing agents in California are not competent to sell homes because in the California residential purchase agreement, there will typically be a request by buyers to pay buyer agent compensation. And one of the risks, and we're just talking one of them, there's three, but one of the risks of offering buyer agent compensation is being part of a price fixing scheme now, or commission fixing scheme. I am going to show that if I can share my screen. Otherwise, I'm just going to talk about it. So let me see if I can share it. We will try this screen. Nope, that's not it. Neither of those screens are window. I am sorry. Oh, this should probably get us there. Share. Okay, so this is, perfect. So this is evidence that buyer agent commissions have gone up in 2025. You can see right before the, I don't know if I can make it any bigger. Let's see if I can. Right before these forms were instituted, buyer agent commissions had been sinking, and this is, well, I'm going to have to make it smaller, huh? And this is because I think in part, people didn't know how to offer them. They didn't know what was going on, and there were some questions about how things would happen. But we can see that since the NAR rule change, and this seems a little early for the rule to have, third quarter 2024, real estate commissions have gone up in 2025. Now, I'd like to share, let's see if I can share the BRBC. Okay, so now I'm going to show you that why, at least in part, these commissions are changing. Buyer agents are being forced by the buyer. Buyer's agents are being forced by the California Association of Realtors and the MLSs to make sure that buyers sign this broker compensation advisory before they show a property. And so what they're doing is they've learned, and when I've sold houses, I've seen this, they've learned that if they're going to make the buyer agree to pay, they are going for the max. They're going for 2.5 and 3% in California, which on freely, I sold, there were 9 multiple offers on my property that was about $1.7 million. And there were a couple of agents that didn't ask for buyer agent compensation. They were working for cash buyers. But the buyers that were working, the buyers who were asking for buyer agent commission were asking for 2.5 and 3%, which I would have thought 2 to 2.5 was a reasonable amount. They were going for the max. Now, we were able to negotiate it down. I'm an attorney. We had multiple offers, but listing agents aren't able to do that. Listing agents have had all their forms removed from them. Listing agents do not have the language to properly counter, and listing agents are not aware and cannot mitigate against the risks. So right now in this video, I'm going to show you the risks. I'm going to put it together in a pretty easy to understand thing. So the California Association of Realtors are forcing buyers to agree to a compensation level before they even see a home. That's like at their weakest point. The buyer's agents are saying it's 2.5 or 3%. And I would think a normal buyer would say, well, that's a lot of money. I'm not going to pay $30,000 on $1 million home, $60,000 on a $2 million home. That's far too much. I'd rather use that for a down payment. And then they're saying, don't worry, they'll get the sellers to pay. And they're sort of succeeding in doing that because in this form, you can see that if we get down to G3 right here, they can ask the seller to pay the 2.5 or 3%. Now, what's very interesting about this is that listing agents have no forms, no language, no instructions from the California Association of Realtors on how to properly counter this. If they're not attorneys, they're not countering legally. Because if I were, I'm an attorney and a broker, if I were countering, I would, let's see if I've got my counter language up. I do not. So let's just think about something. I'd like to break this out into 2 negotiations. One would be for the price of the home and the closing date in those terms. And one would be for buyer agent compensation. So I would bifurcate the process. So I'd say seller hereby unchecks box G3. If buyer is interested in receiving buyer agent compensation for their buyer agent fees, please do so on the attached forms. And in those forms, we've now broken it out into 2 negotiations, but I've also talked to my seller about mitigating against the risks. Those risks being compromising the fiduciary duty of the buyer's agent, steering, which is built in by this forms in this process, because what happens if you say zero? Think about this. The seller has a contract in front of them. It's requesting 3% buyer agent commission. What if they countered it to zero? Would the buyer have to walk because they're paying their buyer, because they've agreed to pay their buyer 2.5 or 3%? Steering is absolutely built into this process. And I'm going to tell you, it doesn't have to be. For instance, they don't have to check. This box shouldn't be there, really. You can't put a box there and then not provide the listing agent with the ability to counter it. They don't have the language. They're not authorized to do it. They don't have the forms. That's because they're not attorneys. And this is a third-party contract. Listing agents are absolutely incompetent to deal with this issue. And because of that, I don't even know how it's happening. If you think of Google says there's 190,000 home sales in California, 85 to 90% of those commissions were paid to a third-party broker. If the stats that I read are accurate, and that's, I would say, is also after selling over 200 homes in California in my career, I'd say that is probably pretty accurate. And every single time the seller walked into the listing and agreed to pay the buyer, the listing agent money, everything was good. But the minute the listing agent allows the seller to pay buyer agent compensation, that buyer has had liability heaped upon them by this process. Compromising the fiduciary duty if they paid a percentage, something that could easily be mitigated against. Steering is something that's built into the process because of these high commissions the buyer's agents are charging. And it's not the law. California does not require the buyer to agree to pay buyer agent compensation just to see a home. The law says on the DRE website, let's see if I have that. The DRE says the timing in this requirement is different from the trade association practice. That's NAR and CAR, which requires a buyer broker representation. I'm sure it's his agreement before an agent tours a home. AB 2992 will also require the agreement to include buyer agent compensation, the service to be rendered when compensation is due, and the date the agreement shall expire, provided the expiration date shall not exceed 3 months. However, what they have said is that it's not as soon as they see the home, it's as soon as practicable. And as soon as practicable would be to me at times, not until you find out what the seller is paying. So you'd go see the property, your agent would call up and say, is the seller offering buyer agent compensation? Or you probably need a lawyer for that, but you'd find out. And then you could decide when you're making the offer, no later than the execution of a buyer's offer to purchase the property. So when you're making the offer, that's when you agree how much your buyer's agent is being paid. That's what the law requires. What the California Association of Realtors is doing is they've built in high buyer agent compensation, which has got to be bothering those clients of the class action lawyers. It's got to be bothering buyers who are unhappy with their prices if the market sells off, and talk to an attorney. I mean, this is a major, major mistake. Now, there's many ways that CAR could remedy this. CAR could design a form that says you must speak to a listing attorney before you sign an RLA with our agents, because our agents cannot advise you on whether you should offer buyer agent compensation. We cannot devise risk mitigation for you, and we can't dynamically do it based on how strong the offer is and how many other offers you might be getting or how many showings. We cannot design dynamic risk mitigation at all. I mean, we can make forms, but you might not always want the buyer to have to jump through all those hoops. Other times, you got a lot of offers. There's tremendous risk mitigation measures you might deploy. Listing agents can't do that. So CAR really should have a form out there that says, if you are going to sell your home and agree to offer buyer agent compensation before you sign this RLA, you should speak with a listing attorney. That's why I started this listingattorney.com, because right now, built into the process is commission fixing, steering, and the way agents do it, compromising the fiduciary duty of the buyer's agents. Hence, any attorney or anyone who's really more interested in this should stay tuned on this channel to see more videos, as I'm going to explain this every day, probably going live like today. I mean, it's not, well, whatever. It might not be live, but I like doing lives. And I have designed a free video series. I created the webinar. I'm going to move it into a free video series, but it's at listingattorney.com for everyone who wants more information. I will also explain to attorneys how you could work together with an attorney broker like myself, or come up to speed and really advise your clients well. And then you'd be entitled to a much greater percentage of the listing agent's commissions. And I have in the video series, I'm going to explain why, I think you might be worth up to 50% or more of the work, because you're providing 50% or more of the value, and you should be getting paid. The listing agent is going to need to share their commissions with you. Thank you. My name is John McConnin. I'm a broker and attorney. Thanks.